Good morning. I'm Gary DeWaal, and this is Bridging the Week, June 24th through 28th, and today is July 1st. Why am I holding a compass today? Because this week the CFTC finally showed what direction it is taking following the horrific collapse of MF Global during October 2011 and the now more than 20-month trial and tribulation of its customers to recover their funds on deposit there. On Thursday, the Commission filed a long-awaited enforcement action in the United States District Court in New York City, naming MF Global Inc., MF Global Holdings, John Corzine, and Edith O'Brien. MF Global is the broker that held the customer funds, you will recall. Holdings is its parent. Ms. O'Brien was the assistant treasurer of MF Global, and Mr. Corzine, who was the former governor and senator from the state of New Jersey, was the CEO of MF Global and the chairman of MF Global and Holdings. In its complaint, the CFTC alleged that all four defendants failed to segregate customer funds as required and misused customer funds. Holdings and Mr. Corzine were charged as controlling persons of MFG, while Ms. O'Brien was charged for aiding and abetting MF Global's wrongful conduct. MF Global was also charged with a reporting violation and for submitting false and misleading statements to the CFTC, while MF Global and Mr. Corzine were also charged with failure to supervise. Simultaneously, MF Global settled all charges against it by promising to pay all former customers 100% of all funds owed to them. Relying on tape recordings of conversations and other evidence, the CFTC painted a disturbing mosaic of the final days of MF Global when the firm was running out of money and time and seemed to be desperately looking anywhere for liquidity to satisfy proprietary obligations. Questions were raised constantly whether funds used for such purposes might be customer funds, and there clearly was a suggestion that the firm believed that customer funds could be borrowed intraday provided they were paid back by the next morning. There was also a suggestion that separate and apart from the violations involving customer funds at the end, from January through May 2011, MFG invested customer funds impermissibly, and that this was detected by the Chicago Mercantile Exchange during a routine audit during May 2011. There is no evidence that this matter was prosecuted at the time. What does this action mean? Well, for the CFTC, they can proceed with their reauthorization and other congressional battles without the cloud of having brought no enforcement action related to the MF Global collapse. For the two individual defendants, it means a challenging time ahead to present a defense to counter the CFTC allegations and restore their personal reputations. For the customers who are now promised 100% of their funds, it probably means some personal satisfaction, although many would have preferred a criminal charge. And for the rest of the futures industry, they have already been dealing with a host of new, costly customer protection measures imposed by the CFTC, NFA, as well as the CME, and probably new ones upcoming too, including the imposition of a very controversial, mandatory required minimum residual amount exceeding at least the aggregate of projected customer deficits each day at some point in time. However, this case also serves as an important warning. When managers, even the most senior manager, knows there might be a problem at their firm impacting a material obligation under law, he or she cannot ignore whisperings of the problem, or worse, seek to encourage others to take actions that might exacerbate the problem. He or she has an affirmative obligation to proactively satisfy him or herself that all is well and that the degree of his or her personal involvement probably is a function of the materiality of the potential problem. See my fuller analysis of this matter on my website. This is important. Oh, and finally, can folks who work for registered financial services firms remember that when they speak on a telephone or write something, even in an email or instant messaging, it is probably being recorded and retained within their firm. It's bad enough to say embarrassing things. It's worse still when the writing or tape of those dumb statements are quoted in criminal or civil complaints, and your public denials today are measured against your prior recorded statements that may suggest something contrary. Also this week, a curious development. You recall last week how I reported that the CME had published new guidance regarding wash sales that were to be effective July 1st. I even reported this on my www site. This advisory dealt with, among other things, inadvertent crosses by so-called proprietary trading groups. Well, following another colorful speech by Commissioner Chilton on June 24th before the Chicago Trading Show, where the commissioner advised it was best to go slow in considering the CME's guidance, as well as dialogue between the staff of the Division of Market Oversight and the CME pulled its proposed guidance on June 28th and reminded everyone that its recently launched self-match prevention facility is optional and not mandatory. This is all very curious, and it'll be fun to hear what really happened behind the scenes. This week also, the U.S. Court of Appeals for the District of Columbia upheld the right of the CFTC to impose commodity pool operator registration requirements on certain mutual funds. Previously, the Investment Company Institute had argued and lost before the District Court that the CFTC had not done a proper cost-benefit analysis to justify requiring certain investment companies to register as CPOs with it. And finally, with only 12 more days before the expiration of the CFTC's exemptive order on the application of its Dodd-Frank cross-border rules, Commissioner Weechin became the latest commissioner to argue for coordination among the G20 jurisdictions to ensure sensible adoption of a cross-border policy that is clear and workable and includes an orderly transition period. Unfortunately, there still seems to be little appetite within the chairman's office for any policy other than American regulatory colonialism. Non-U.S. swap dealers, as well as non-U.S. branches and guaranteed subsidiaries of U.S. swap dealers, are best advised to figure out how to be compliant with all their Dodd-Frank requirements in just a few days to the extent they conduct business abroad with U.S. persons. By the way, good luck figuring out who U.S. persons are. Well, that's it for this week. This is a short week because of the July 4th holiday in the U.S. and the July 1st holiday in Canada. So therefore, until next week, this is Gary DeWaal, and have a good, shortened week.